So let's start the final session of this conference dealing with sanctions and compliance, certainly one of the hottest topics, and we partially touched upon this topic earlier yesterday, but there are plenty of issues to discuss, and we have a very distinguished panel, which will be chaired by Noah Rubins QC, whom have known for quite a long time, with whom we work together at Freshfields. Noah is one of the best known practitioners working on in various regions of the world, but he's one of his primary areas of expertise is working on CIS-related disputes. His Russian is perfect, as are his oral advocacy and written advocacy skills. Noah is based in Paris. He is a partner with Freshfields there, doing primarily investor state and commercial arbitration. Noah, over to you.
Thanks so much, Yarek. Welcome to everyone to this panel on sanctions and compliance, a narrow passage. Why a narrow passage? Well, I didn't make up the name of the panel, but I suppose a narrow passage because states and international organizations in general try to use sanctions of various kinds to limit the freedom of action of private parties in order to advance their policy goals, and in particular, their international policy goals. And so to the extent there are sanctions in place, it is designed to push private actors into a narrow passage. That passage becomes even more narrow when there are multiple sanctions regimes imposed by different states with respect to different kinds of entities in different places. And so these limiting regulations and laws which intersect each other, making that passage narrower and narrower. In today's world, in relation to the CIS, there are significant sanctions in place with respect to, in particular, Russia, but also Ukraine and Belarus. There were previously sanctions of a limited sort in place with respect to Turkmenistan and Uzbekistan. I understand those are no longer in place. But the ones in which that we run into the most often in commercial disputes relate to Russia and in part to Ukraine. My first interaction with international sanctions had to do with Belarus several years before the present Russian sanctions were imposed by the United States and the European Union. It was as arbitrator in a case involving a Belarusian person who was the UBO of a company that was a party to the arbitration. That person was a respondent, and the arbitral tribunal was ad hoc, administered by the LCIA. Although the issue of sanctions wasn't raised by the parties, the LCIA raised it to us very early on to say, you know, there are EU sanctions with respect to this person, and you may have issues. What kind of issues? You know, we're not paying anything to anyone, and we get our money from the LCIA that's administering the. Well, as it turned out, first of all three of the arbitrators were EU nationals, which made it particularly difficult because they were EU sanctions, not US sanctions. And the real question came because the respondent, the sanctioned entity, had advanced a counterclaim. And the question was, if we satisfy the counterclaim and we issue an award, will we be conferring a benefit on that person? Because that would be prohibited for an EU national to do under the sanctions regime. And so ultimately the question was, do we need to ask for a license from the European Union to render an award? As it turned out, we declined the counterclaim, so that didn't come up, but it very well might have. And so what we're going to hear today is sort of the general perspective on these various sanctions regimes, particularly US, EU, and also now the UK, which has its own sanctions regime that's forming. and the way in which it impacts on parties, on arbitral institutions, and on arbitrators in the area of disputes. We have three wonderful speakers to tell you all about that today. I'd like to introduce them in the order they will be speaking to you. And I do hope that during our panel, you will feel very free to enter any questions that you have into the chat. I will be monitoring that and will be trying to put those to our panelists as early as possible. So don't wait till the end to put the questions into the chat. We will do our very best to address all of them. So to our speakers, our first speaker is Viktor Rykov, who is an international lawyer at Nexign JSC. Nexign is a Russian IT company that supplies core software for the big three telecom operators. And Viktor is in charge of international tenders all over the world and participating in sanctions compliance. So he has hands-on experience in the sanctions area. He's also very much involved in the dispute resolution world, doing academic activities. He publishes on sanctions. He coached Vismut teams, and he has an LLM from Finland in transnational business law. And he'll speak today on giving an overview of the recent US sanctions regime and its impact on the law governing contracts. After that, we'll hear from Ays Lidzhanova, and Ays is a senior associate at Egorov Puginsky in St. Petersburg. She has extensive experience representing clients in all kinds of disputes, and in particularly in arbitration. She also deals with the broader issues of restructuring and insolvency, asset tracing and recovery, and she is widely published. Today, she will be speaking about life after sanctions, Russian parties in search of a new arbitration forum. And finally, Ben Wells, who is a solicitor advocate with CANDEY, and he is a fluent Russian speaker based in London. Most of his work deals with Russian-speaking clients, and he has a broad practice in arbitration and the English courts, dealing with all aspects of commercial activity, trade, investments, banking, shareholder disputes, and international civil fraud and enforcement. Ben is also the founder and chairman of RusFor, which is a networking group for Russian-speaking legal professionals. Those of you who are not a member should join up. And he's very active also in various organizations linking the United Kingdom with the former Soviet Union. With that, I will turn to Viktor for the first topic so that he can tell us about US sanctions and their impact on choice of law. Viktor, the floor is yours.
Thank you for the introduction. Thank you for nice words. And I would also ask you to give me some control, or I can already do that. Yeah, I can share a screen, right? And I will just proceed in a sec. So as was already told by Noah, I will speak about US sanctions and about their impact on the law governing contracts. In particular, I will tell about about interplay between mandatory legal order, which sanctions comprise of course, and their interplay with freedom of contract on the other side. I will cover it in two blocks. I will speak about US sanctions a bit to give you the taste of it and to give you the idea how they are organized. And then I will speak more specifically about their impact on the law governing contracts, on the governing law clauses in the commercial contracts. So let's start with the US sanctions in general. There are several sources in the US jurisdiction, which you can see in the lower part of the screen, which empower the president to issue executive orders. And if you go to the official webpage of the US, of the US president, you will find dozens of such executive orders there. Each president administration starts with the new sanctions regimes. Sometimes they enact totally new sanctions. Sometimes they prolong the course of previous administration. And these executive orders give the general framework for the actual enforcement of sanctions. Then actual enforcement of sanctions is done by the Office of the Foreign Asset Control, which issues directives. And these directives, they basically provide specific prohibitions which already should be followed by the US citizens and US and any entities which are affected by US jurisdiction. So just to give you an idea, Biden administration, as many of us might know, quite recently, I think it was on 20th of April, enacted a new executive order which concerned Russian Federation specifically, and there were two novel things in this executive order which were not before, let's say, new to effects which were not before in place. Firstly, this executive order targeted Russian technology companies involved in the malicious cyber activities against the US. And this is the topic for the big separate discussion, what exactly should it mean, but we already have some companies in this list. And the usual idea behind this is that these companies somehow cooperated with Russian intelligence services to interrupt US elections, to interrupt US business activities of US companies, and et cetera, et cetera. So as I said before, the executive order of president just gave the general framework saying that malicious cyber activities against the US. Then if we open directive, which was enacted by the OFAC of EAC, we will find there that there was specific list of entities affected by this general concept provided by US president. And the second part of this, I mean, not like second part, but another like important feature of this Biden executive order is effects on the Russian financial system. Basically, executive order stated that the government of Russian Federation should be targeted. And then it explained that government includes central bank, national wealth fund, and the Minister of Finance of Russian Federation. And then US financial institutions now are prohibited to deal with the, as you can see on the screen, denominated ruble or non-ruble denominated bonds issued by these entities, and lend ruble and non-ruble denominated funds to these entities. So this is the general idea, like let's say how you could see just recent sanctions enacted in the general framework, how US sanctions usually operate. But the most frequent issue discussed worldwide is extraterritorial effects of US sanctions. And before we come to it, and before we discuss it into detail on the, for example, I will discuss it on the basis of effects on the law governing contract, and my colleagues will discuss it later on the questions of access to justice and the questions of procedural effectiveness of like fighting against sanctions in commercial disputes. This is important to remember that sanctions as such is the part of US domestic legal order. And this is the same for like any other sanctions as UK sanctions, Ukrainian sanctions, and Russian anti-sanctions. So this is the part of public law being embedded in the specific legal order. And they, as such, by themselves, do not have extraterritorial effects, like they cannot. But then, of course, US sanctions are the most frequently, how to say, mentioned, because of the US strong economic presence worldwide. And then UK follows, and EU follows, and then other jurisdictions follow. Because as you might know, Ukraine, for example, has like dozens of sanctions orders as well, but we do not discuss them that much because effects on the economic and on a business are much lower. So with this in mind, I would suggest now to go further and to look at the specific issue of the effects of sanctions on the governing law clauses in the contracts. And to give the idea why this is important, I will just say that we will cover it in the 3 parts. Yeah, we first will see recent Russian cases involving English law, because I took English law as an example of governing law clause. Then we will check whether court's vision was in line with Russian civil code actually, and how to work with governing law clauses. And then we will see how Russian courts were expected to apply governing law clauses in the context of sanctions in line with Russian civil code. So let's start with the quick overview of just 2 recent cases in this area. There were Instar Logistics and Target and Google. So just 2 words before I get into much of detail. What is the idea? We frequently have disputes involving multi-jurisdictional issues. For example, in La Mesa, this was the Cyprus entity with Cyprus Bank, but there was a BVI holding group holding 100% of interest in the La Mesa, and this BVI holding group was actually held by Mr. Vekselberg. Yeah. So, and then we had English law clause governing the contract. So English courts consider disputes between La Mesa and Signature Bank, about which Ben Wells will elaborate later today. And we had like many various issues at one plate. And the question is how to deal with this. Hopefully, in the course of this presentation, I will help out a bit how I see these issues should be dealt with in the in the area of Russian civil code and law governing clauses. So we had this case in Instar Logistics, which concerned. I would like to discuss one specific issue which it concerned. It basically stated, the court stated in this case that interpretation of master agreement in the light of US sanctions necessitates changing a governing law clause to such a degree as to wholly exclude effects of English law on the Russian party. So basically there was English law clause in the contract, and the court stated that to preserve, fairness towards Russian party, we need to exclude effects of the this English law clause on the Russian party, and it proceeded to apply Russian law. That was it. Then we have this Target and Google case, which, as you might know, we just had the first instance judgment in that case.
Victor, can I just interrupt for a second?
English law governed the dispute. Yeah.
On the Instar case, can you just explain? I don't see how sanctions led to the exclusion of all effects of English law on the Russian party. Was that only the effects of sanctions on the Russian party, or just like applying Russian law and ignoring the clause? How is that related to the US sanctions? It doesn't make much sense.
Yeah. So basically what Russian courts usually say, they say, okay, we have these US sanctions in place, and we have also foreign law clause applying to the to this dispute, to this contract, and they just make next conclusion out of these 2 facts, that we should not apply foreign law clause because there are US sanctions in place, and because this foreign law is likely to allow these sanctions to be enforced. But they do not really show how this, but I will try to address this in a minute, basically. But what should be done by Russian court, they should just basically establish contents of the foreign law, and then answering the question how this foreign law interacts with the US sanctions to make any further conclusions. But if we look at the Instar Logistics and at Tsargrad case as well, we will find that this reasoning is absent from these judgments. They just jump to the conclusion and leaving us with the idea that US sanctions actually have extraterritorial effect, and maybe sanctions actually are enforced by English courts just like that. But this is not actually true, and this is this can be shown from La Mesa and BCGI, etc., etc. So this is the point. Have I answered the question? Yeah. Okay. So just to give the, as I told, short comment on the Tsargrad, the case involved English law clause as well, but actually, if you read the judgment and if you read the interim order of the court, interim judgment of the court on the procedural matters, which was rendered a bit earlier, you will not find any clear idea about like English law. So basically, court did not really apply English law, at least in the sense I read these judgments. And only relevant statement in the Tsargrad and Google case was that US public law, as you may see, shall not create rights or obligations for Russian parties because of the absence of extraterritorial effects. And in my view, this is actually a misleading statement, because of course Russian like US sanctions will not be enforced in Russia, but this does not mean that they do not create rights or obligations for Russian parties acting in international. I believe that such statements should not be made by courts lightly. So now with these two court judgments, we might now look at the how to say, correct approach, or the approach which should not be implied by the court judgments, but should be actually put in the court judgment in order to persuade that the contract applied correctly, foreign law applied correctly, and Russian applicable law applied correctly. So what we now can discuss. We have three principal clauses in the in the Russian Civil Code. This will be the clause 1191, saying that the Russian courts are expected to apply foreign law in the light of the application, official application in the country of origin, of the doctrine, and of the case law. And then Article 1192, saying about mandatory law interaction with parties' freedom of contract. And then Article 1210, saying that parties are allowed actually to choose any foreign law to govern their contract. And if we look at these three articles of the Russian Civil Code, we will find out that actually Russian court may not disregard parties' choice of law. And of course, Russian court is expected to ascertain the law applicable to the contract before disregarding any specific parts of the foreign law. And then, as I previously told on the example of Instar Logistics, we can easily compare it, for example, with La Mesa or BCGI, because both La Mesa and BCGI are actually parts of course, English law order, because case law in England is the principal source of English law. And then what should be done? Russian court is expected to look into the specific circumstances, to look into comparable circumstances under English law, and to check whether these are compatible or not. And once it is done, it can decide whether English law is actually applicable or it's not. And of course, as Ben Wells will later elaborate, La Mesa reasoning is unlikely to be deferred because in La Mesa, Russian party affected by sanctions, its interests were, how to say, impacted by sanctions, and Russian courts will not allow the same results. And of course, this case will show that there will be conflict between English law courts and Russian courts' vision. Then BCGI reasoning is actually very similar to logic in Uraltransmash. In BCGI, the party who was affected by sanctions actually tried to avoid payment. It was the Petroleas, it was the Venezuelan petrol company. And the English court found that there is no way US sanctions operate in such way, in this fashion, and found that sanctions do not automatically allow to avoid the payment. And this is very similar to what was found in the Uraltransmash case. And here, in my view, English court and Russian court stay on the same footing, though they stay on this separate legal footing, of course, because once this was Uraltransmash is based on Russian law, and then BCGI is based on the English law. So so my idea behind all this reasoning is as follows, that actually Russian courts, when dealing with the foreign law governing contracts in the sanctions contexts, they have three possible ways to react. First, they may reject application of relevant legal norms once these legal norms are established. Second, they may apply English law due to its basic compatibility with Russian public order, which I said just was a BCGI example from in comparison with Uraltransmash. And the middle ground approach, which is unlikely to be, how to say, seen in Russian court's judgment, but which seems to me the most reasonable from commercial sense, is the deference to the parties' intentions to allocate sanctions risks. So we might imagine situation when actually Russian party accepted sanctions risks in order to gain commercial advantage. And if this can be read clearly from the parties' contract, it's not really clear why Russian courts should impose burdens of US sanctions on another party to the contract. This will be the third way to deal with it, though unlikely to be present, I suppose. And just to give you, I don't know, have I managed to give you the food for thought and a general idea of these concepts interacting? So I tried to put it visually a bit, as we may see what interacts with what. And we may see that Russian anti-sanctions law and US domestic sanctions are in the separate part of the picture. And then once Russian party, for example, contracts with the, I don't know, some entity, like let's say some financial institution with interests of US company, they bring into the picture basically the effects of US sanctions. They start to interact with the Russian party from the one side, and from another side there is a public order of Russian law. And then the, how to say, extent of these effects depends largely on the applicable law. And once we establish that this applicable law gives effect to these sanctions, they should become binding on the parties. Yeah. Once we establish that there is no effect, we do not enact this specific sanction, and the parties' relationship stays intact. So I think this is about what I wanted to tell you. I hope I managed to shed some light on this. And if you have some questions, any questions, I will be glad to address it.
So I hope our participants will type furiously in the chat box. In the meantime, Viktor, I just want to return to some of this because it's not entirely clear to me why the Russian court would even consider nullifying or disregarding a choice of law clause because of US sanctions, unless it's US law that's applicable. It's very confusing to me because, I mean, imagine, for example, Swiss law applies, right? There's no sanctions. Switzerland has no sanctions against Russian entities. But one of the parties to the arbitration, the non-Russian party, is impacted by US sanctions in such a way that the outcome is affected. I mean, it's unclear to me how the governing law has anything to do with that. It's the nationality and economic activity of the parties, and particularly the non-Russian party, isn't it?
I mean, no, I agree. I totally agree with you. And it might be that this seems to be misleading because in my head, these are also separate concepts. But idea which I tried to convey here was when I read Instar Logistics first, and then I encountered Taggart, and separately of that, I read like some English law cases, and I thought, why Instar Logistics conveys such logics, saying that we need to read this clause in light of US sanctions and to change it, and then basically replace an English law with the Russian law. And we cannot find these tools in Russian civil code. I actually can tell you that we have some much more, I would say, elegant rules in Russian civil code. If we go to the Article 1191, we will find that the court may apply Russian law if it cannot, let's say, establish foreign law applicable. And basically, the court could do something like that. The court could say, okay, please show me how sanctions are addressed in the English law context. And then parties will try to persuade the court in some way to show the court this and that case, to bring BCGI, to bring La Mesa, for example.
Yeah,
and,
I mean, but Victor, the problem that I see, I mean, on this slide that you've got here, this quote this is from Tsargrad, right?
yeah,
U.S. public law, due to absence of the extraterritorial effects, shall not create rights or obligations for Russian parties. To me, that's neither here nor there. I mean, okay, in a sense, it's legally true, factually probably false. Like as a matter of practical reality, it's probably false, right? But it's irrelevant to the question as to the law governing the party's contract, which they chose, right? And it's not even, and it's for me, it's separate, for example, from the issue of the anti-sanctions regime in Russia, where, and you might comment on this a little bit, one of the, as I understand it, one of the aspects of it is to say there's now a Russian law that says if sanctions impede the progress of an arbitration, then the Russian party that's signed the arbitration clause can ignore it and come to the Russian courts to get justice, so to speak, right? Now that has a certain internal logic. I'm not saying it's good, bad, or indifferent. There's a legal logic to it, right? That says if there is circumstance A created by these sanctions, which we don't like, we don't consider them legitimate as a matter of public policy, then we are going to have a result of invalidating the party's choice. That makes sense. This doesn't make sense to me. I just don't see where it's like coming from out of the sky. It's, and indeed it's completely contrary to those provisions of the civil code that you were mentioning before about freedom to contract, freedom to choose foreign law, all that kind of stuff.
If you say about Tsargrad and Google, I would say that in my view, there were pretty, like say, too much of implied reasoning in the court judgment. What we just discussed, what I just tried to say about Russian civil code, was expected to be in the judgment. And I put on the screen, the court actually have not addressed the governing law clause. They simply state in passing that there is English law applicable to the dispute. And then they also said that US public law has no extraterritorial effects. And as you correctly say, that these are two separate concepts and two separate, I mean, they interact, of course, but they are quite separate blocks of like bigger picture, yeah. And then court proceeded to its own reasoning and to its own ideas of saying that Google actions were actually wrong, yeah. But there was really little of legal basis under these, of like, let's say not maybe legal basis, but the idea which basis is actually applied by court. And what I tried to show here is that courts are actually expected to show this basis. They anyway need to do that. They either need to say that we apply Russian law because of that, that, and that, or we apply English law only partly because of that and that and that, or we do not really need to go into that because we have contract and the contract does not contradict Russian public order and we just apply contract, that's it. But I could not find persuasive reasoning on that point in Tsargrad. This is why I just highlighted this small bit. And I found clearly contradictory reasoning in Star Logistics as far as it goes to foreign law applicable to the contract. And this is why I put it on the screen as well. So my message here is that we should not have such, how to say, such judgments.
I understood that to be your thrust.
Yeah.
I was just wondering whether there's more logic, because it just seems almost like, and there's no offense to the Russian courts, it seems like they're sort of reaching out, sort of striking out as sort of like, we're being attacked and we attack, and if our interests are going to be ignored, we're going to ignore others' interests, which is a little bit illogical, but whatever. Anyway, maybe there will be further questions about that in due course, but let's pass on now to Ays to make sure that we have time for everything. Ays, you're going to tell us about the search of Russian parties for an adequate arbitral institution.
Yes, correct. Hi, Noah, and good afternoon to the participants of our today's conference. Okay, well, first of all, introductory remarks. Well, it's not a secret that sanctions imposed to certain Russian individuals and legal entities since 2014 have had a substantial impact on international arbitration involving Russian parties. Sanctions may create various practical problems at almost all stages of arbitration. First of all, if we speak about the EU-based arbitral institutions, which have been traditionally preferred by Russian users, we shall note here that in its joint statement, the LCIA, ICC, and SCC emphasized that although sanctions do not affect the institute's impartiality and neutrality, they are still subject to EU law and are required to observe EU sanctions regulations. Thus, in order to be able to accept payments of registration fees and costs, the EU-based arbitral institutions are required to have compliance processes and check whether a party to an arbitration or its ultimate beneficial owner or any related entity is subject to sanctions. But as you, of course, can imagine, the parties may not wish to disclose such sensitive information as UBO at the stage of assessing the possibility of arbitration. The EU-based arbitral institutions may be required to obtain a license from their governments, allowing them to perform their role in the arbitral proceedings. However, it can take several months, delaying the arbitration and involving more expenses to lawyers, and moreover, the exemption may only apply to a specific amount of money for a specific purpose. If subsequent payments have to be made, separate applications may be required. So I am on the first slide still, so we can proceed with. Yes, thank you so much. The second practical implication I'd like to address is that sanctions can also have an impact on the choice of arbitrators, particularly arbitrators who are residents or who have connections to the United States. Such arbitrators may also need to obtain a license before agreeing to take on appointments. This can also apply to law firms and experts who are residents in relevant states. Another important point to bear in mind is that banks based in a sanctioning country, particularly in the United States, if the payment is in US dollars, may delay or even be unable to process arbitration-related payments, including arbitrators' fees. And it will all depend on the status of the persons ordering such payments. Another point is that the sanctions may also, in theory at least, prevent enforcement of an arbitral award in favor of a sanctioned person in a state that has adopted sanctions, or again, at least in theory, prevent enforcement of an award against a sanctioned person in Russia. For this reason, Russian businesses have been increasingly looking towards alternatives to resolve their disputes. Yari, can we put the next slide here, please? Thank you. So what could be the alternatives? Firstly, Russian arbitral institutions. But these institutions are mostly preferred for domestic disputes, and a difficulty which may arise here is that the Russian party will need to convince a foreign party to transfer the disputes to them. Second option we may look at is permanent arbitral institutions in Russia. So ICC has been recently licensed to administer international commercial arbitrations where the seat of arbitration is Russia. So does the Vienna International Arbitration Center. But the problem we see here is that they still may face challenges discussed above. Thirdly, Asian arbitral institutions such as HKAC and SIEC in Hong Kong and Singapore, respectively. HKAC has been licensed for some time now, and just this month, SIEC has also been licensed by the Russian Ministry of Justice. And in the latest Queen Mary University of London survey, SIEC was ranked as the second most preferred arbitral institution, and Singapore jointly ranked with London as the most popular seat in the world. So as venues, Singapore and Hong Kong, they both are neutral. They haven't introduced any sanctions against Russian legal entities and individuals. They have supportive legal infrastructure and judiciary, and they ensure accountability, corruption-free governance, and access to equal and fair justice to all. As arbitral institutes, HKAC and SIEC are neutral and impartial. They, as I mentioned, have a great reputation, flexibility, transparency, track record in enforcement, and they have international staff and high quality of hearing facilities. These both institutes have statistics of administering cases of Russian users, more than 20 cases for HKAC and more than 10 cases for SIEC. And they both expect an increase in demand from Russian users in the next years. HKACs and SIECs rules are updated regularly to reflect current international best practice. They are progressive and they provide for resources for saving time and costs, such as early dismissal, emergency arbitrator, expedited procedure, multiple contracts, consolidation, and joinder.
Ays, do you mind if I interrupt for just a minute?
Sure.
So I'm sure the people at Hong Kong and Singapore will thank you for the plug. And they are, of course, lovely institutions with great experience, and we are seeing them quite a lot in Russian contracts. But are they really insulated from US and EU sanctions to a greater degree than LCIA or ICC?
That's exactly what I'm going to cover with my next slide.
Oops, sorry.
Yeah, so just in about a minute, I'll address all these issues as well. So what we see from public record is that SIEC is in process of arbitration of a sanctioned party. It's disclosed information that they have power machines arbitration now, and that so the bank's compliance was overcome in that arbitration by payment of arbitration fees being made by legal counsel working on the case. What I'm going to say is that, however, while choosing a neutral arbitral institution may be helpful, it's not definitely a magic pill against sanctions. And the sanctions regime may still create potential issues in a number of ways. First of all, if the applicable law of the dispute, either by virtue of the seat being in the relevant state which impose sanctions, or because of the law applicable to the merits of the case, may be a law of such state which imposed sanctions. So, for example, EU sanctions may arguably be applicable to a dispute by virtue of parties' choice of English law, or, for example, Paris as a seat. Another problem which still remains here is that even if the institutions, such as Asian ones, may not need to wait for a license to administer the dispute, certain arbitrators may still be unable to accept appointments, and the banks may still be unable to or even unwilling to carry out transfers involving funds of persons under sanctions. And in my opinion, there is still an issue of enforcement of an award in favor of a sanctioned person in a state that has adopted sanctions. And one of the other issues is that it remains unclear whether it is necessary to revise the arbitration clause, for example, in relation to contracts for which licenses have been obtained in the respective countries, and accordingly, which are not subject to sanctions prohibitions, and in relation to contracts entered into before the enactment of the sanctions. So the conclusion here is that transferring the arbitration forum to neutral alternative jurisdictions may not actually resolve all the threats and issues connected to sanctions-related arbitration. And unfortunately, we cannot find a universal perfect solution for the problems that can arise in international arbitration as a result of imposition of sanctions. What we do is we consider each case individually in order to find the best solution, and we only can say here, in my opinion, that the future will demonstrate the impact and will tell the effect, what the effect of sanctions will be here. So thank you, and I'll be happy to answer the questions if there are any.
Thank you very much, Ays. To what extent is this really sort of a theoretical discussion? I mean, I spoke last year at some point to Jackie, the head of the LCIA, and I posed her the direct question as a member of the LCIA court. I said, look, everyone's talking about sanctions, but other than my own personal experience, which I described, which worked out just fine, I've never actually seen sanctions interfere with an arbitration. Like, I've never actually seen it have a real impact. And Jackie said to me, I've never seen it either, which really surprised me. That is to say, the LCIA, under all that, like sitting in London, probably at the, well within the ambit of American extraterritorial power, let's put it that way, as well as having at the time EU and budding UK sanctions, they'd always found workarounds. They'd always found ways to make the arbitration go ahead. So is this all sort of like maybe in the future we'll have these problems, or is this sort of under the radar? There really are a number of problems happening.
Well, if I can rely on public records, is that, for example, the case I mentioned, Power Machines, it first started at ICC. And since they were unable to proceed the arbitration there, they had to shift to SIEC. So that's the case. The practice which is known to practice and which was described by Power Machines itself. And there are others, clients' requests in our practice when we see that the clients have been waiting for arbitral institutions, European arbitral institutions for obtaining the license. And it did took more than half a year for them to resolve the issue. So what we see is indeed an increase in demand on advices on what the alternatives can be. So in my own practice, it's not just a theoretical discussion, unfortunately, it's just what we have.
Thank you very much. All right, now we'll pass on to Ben, who I understand is in the airport in Riga on his way to, of all places, Tumen, a lovely town. I was there in, I think, 1993, and it should be almost coming on to spring there. Anyway, so if we hear a Latvian boarding announcements, we'll know why. Ben, over to you.
Thank you, Noah. You covered that off very nicely. I did want to say, if there are any announcements on traveling through the airport, I do apologize in advance. Hopefully they won't be too loud and I will speak through them. Today, I'm going to be discussing sanctions, access to justice, and covering the introduction of UK sanctions and recent case law, both a bit from the United Kingdom and touching on a couple of things that Viktor mentioned from the Russian Federation as well. I'm just going to share my slides with you. Okay, hopefully you can see the slides there. And starting off with the UK sanctions regime itself, this has come in very recently. So on the 31st of December, and it was due to the UK leaving the EU. And it's meant that we've tried to really mirror the regime in Europe and to be as aligned as possible. And I think that it's got lots of the elements in there. There are just a couple of differences. So for example, ours are a bit denser and more complicated to navigate. The reason for that is lots of the defined terms are contained in other documents. So for example, in the Sanctions Act. So you might have to have a few documents out in front of you in order to get your head around the provisions. Once you get past that initial complication, the government publishes its UK sanctions list, which provides details of designated persons under the Sanctions Act. And this list also covers which sanctions measures apply to specific persons and a statement for the reason of the designation. As governments increasingly rely on sanctions as a tool for foreign policy, new entities are added to and removed from the sanctions list all of the time. So over the past 5 years, the average number of designated entities has increased significantly. Now,
if you press F5, that will maximize the presentation so that it will be full screen. It will be better for us to see. Just F5, or there's a bottom. There's a
not working for me. I apologize because then I lose all of my screen.
No worries.
So if you do breach UK sanctions, that's when monetary penalties can be imposed. It's where there's a connection with the UK, and it's the Office for Financial Sanctions Implementation, or OFSI, that's responsible for ensuring UK sanctions are implemented and enforced. The penalty threshold, where there's on the balance of probabilities a breach, and the person committing it knew or had reasonable cause to suspect they were committing a breach, is for one of the following conditions: that the breach involved funds or economic resources being made available to designated persons. If there's evidence of circumvention, so by making arrangements to circumvent the law, a person not only breaches the law, but also attacks the integrity of the system. Or if for some other reason, OFSI believes that a monetary penalty is appropriate. Also, if you haven't complied with the requirement to provide information, that can be very serious, and OFSI again can pick cause with that. There's a set procedure for calibrating the value of the fine. which is communicated to the wrongdoer, who has two rights of appeal, one to ministerial review and another one to an appeal before payments. Penalty details to try and discourage people from doing this kind of thing are then published to the general public. I'm just going to run over one of the instances where that happened. That was in fact under the EU sanctions regime to which the UK was a part, and it was against Standard Chartered Bank in February 2020 for an excess of £20 million. And it took place following the bank's voluntary disclosure of 102 loans which were made to Denizbank, which was a wholly owned subsidiary of Sberbank in Russia. And Sberbank, as you may have thought at the relevant time, was subject to restrictive measures under the EU provisions. As Sberbank's majority-held subsidiary, the restrictions also applied to Denizbank. And OFSI assessed this. While there were some loans which were permitted, around 70, with a value of £226 million, were not. And they assessed that Standard Chartered had been aware of the sanctions regime, but needed to take compliance steps and had initially actually ceased all business with Denizbank when it became sanctioned. However, they sought dispensations enabling loans to be made, and they considered that an exemption was applicable. But OFSI looked at this and decided that in fact there was no applicable exemption, and therefore they'd been in breach of the EU regulation. So for this one, Standard Chartered applied for the ministerial review. The minister had a look at it, and in fact they said that the fine was completely as expected and there would be no reduction. So there's a real possibility now that other entities will be fined under the UK regime, and in order for that to happen, there must be a UK nexus. So the UK nexus covers off all individuals and legal entities in the UK's territory, as well as all UK nationals and legal entities established under English law. So that includes their branches as well as transactions using clearing services in the UK, which is the big thing which catches the US sanctions that Viktor was discussing earlier. So as we've seen from the example of Standard Chartered, it's not just entities on a sanctioned list, but in fact entities which have a relationship with a sanctioned entity that create a really big risk. And this leads us to something called the 50% rule. And this wasn't under the EU sanctions regime, but it is present under the US one. What this means is that now the system's changed slightly in the UK, and where a non-designated entity is owned more than 50%, there's an automatic asset freeze against that entity and prohibition on making funds available without a license taking effect. And this Russian sanctions regime has been upheld as well in England through something called the Russia Sanctions EU Exit Regulations 2019, which also came into force on the 31st of December 2020. And while they largely mirror the EU sanctions on a prohibition for the sale, supply or use of goods, technology, for example, those with a civilian or military purpose, as in Annex 1 to the EU regulations, or a prohibition on the sale of items which are suited to deep water or Arctic oil exploration and production, as listed in Annex 2. And the largest difference between the UK and EU sanctions in this particular part is that under the EU, it's those items for use in Russia, whereas for the UK, it's not only for use in Russia, but also to a person connected with Russia. So as you can imagine, this brings in a whole plethora of people. What's the test for a connection to Russia? I'm not so sure. Does it mean that you know someone in Russia? Does it mean you're in business with someone in Russia? I think it's quite unclear at the moment, but there's clearly a really big area for caution and something that people need to look out for. In terms of the impact, sanctions in the UK and elsewhere greatly impact on private contracts. When it comes to sanctions, one of the legal remedies sometimes sought is that of frustration. And quoting Lord Radcliffe in the 1956 case of Davis Contractors, frustration occurs whenever the law recognizes that without the default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. As you can see, this has quite a narrow way of being construed. It only occurs after the contract has been formed. This is very relevant to some of the cases that I'm going to discuss in a moment. It must be so fundamental as to be regarded by the law as both striking to the root of the contract and as entirely beyond what was contemplated when entering into it. And it can't be the fault of either party. It actually renders further performance either impossible or illegal. And a contract which has been frustrated is automatically discharged, and the parties are excused from any future obligations. However, the illegality I've just referred to is illegality within the jurisdiction where the contract is performed and or the law of the contract. It doesn't take into consideration foreign law, such as sanctions provisions in, for example, the US or Russia. So might it be best for companies which know that they have contracts which may be subject to sanctions to agree upon express contractual provisions, for example, force majeure or specifically worded sanctions clause? We're going to look at a couple of English case law examples of La Mesa and Banco San Juan to see what happened in such instances. So in La Mesa Investments Limited versus Synergy Bank Limited, which was heard in the Court of Appeal, it concerned the interpretation of a facility agreement, which was entered into between La Mesa and Synergy in 2017. La Mesa was wholly owned by an individual who was subsequently subject to the imposition of sanctions in the US. The issue raised in appeal was whether the terms of the facility agreement required Synergy to make interest payments to La Mesa in circumstances where the payment was likely to result in the imposition of secondary US sanctions on Synergy. This really turned on the meaning of the express provisions of an agreement, provided Synergy was not required to make any payment where, and now quoting from clause 9.1 of the agreement, such sums were not paid in order to comply with any mandatory provision of law. Note that's any mandatory provision of law, so not just keeping it to the law of the contract or the law of the place where the contract is being performed. Now, at first instance, the court held that non-payment fell within the scope of clause 9.1, and the Court of Appeal agreed and dismissed La Mesa's appeal. In finding so, it had particular regard to three aspects, which were, firstly, the terms of the EU blocking regulation must have been known to the parties and to the drafters. The fact that clause 9.1 is a standard clause relied upon by many in the banking industry. And thirdly, that at the relevant time, the US secondary sanctions would have been a potential problem affecting parties to agreements for the provision of capital within the EU. So this was very much at the forefront of everyone's minds when this clause was drafted. According to the Court of Appeal, now quoting from paragraph 44 of its decision, the drafter of clause 9.1 must have intended the borrower to be capable of obtaining relief from default if its reason for non-payment was to comply with a foreign statute that would otherwise be triggered. The drafters knew that the blocking regulation regarded US secondary sanctions as imposing a requirement or prohibition with the EU parties were otherwise required to comply. Following hotly off the heels of La Mesa was the case of Banco San Juan Internacional and Petróleos de Venezuela. And in this case, the commercial court granted summary judgment in favor of the bank, which was seeking to recover payments under credit agreements entered into with the Venezuelan state-owned oil and gas company, Petróleos de Venezuela, or PDV. And that was in 2016 and 2017. The relevant clauses of the agreement read, sanctions. PDV will not repay loans with the proceeds of business activities that are or which become subject to sanctions imposed by the United States. US sanctions were subsequently imposed on Venezuela in 2018 and 2019, and PDV argued they were binding on it. So those sanctions were after the contracts had been entered into. In this instance, when interpreting the sanctions clause, the court rejected the suggestion that Lemessa, which we just talked about, meant it's perfectly normal to suspend payment obligations in commercial agreements where payments would otherwise be in breach of US sanctions. It found this authority and others were simply decisions on very different facts, and that each case will turn on the interpretation of the contract in question. So the court held there was an exception to allow payments where PDV applied for and obtained a license. And in fact, PDV had failed to show it's discharged its obligation to apply. In fact, it failed to show that it would apply at all, or if it had have applied, why its application would have failed. So even more importantly, the relevant clause did not suspend PDV's payment obligation. In fact, it made no mention of a suspension at all. And that's really the problem with frustration, because it brings the contract to an end as a whole. So it's necessary to rely on these other clauses wherever possible. Turning to Luba's question, which was in the chat function, the payments in this instance was due to be made in US dollars to a US bank, and it was very possible that the transfer would have been blocked. Even so, the court got a little bit creative in this instance, and they suggested that the payment could have been made in euros to an EU bank account, and that Banco San Juan would have been amenable to making appropriate amendments to the agreements to allow that form of payment. Moving on to the new...
Ben, before you move on, did PDVSA bring up frustration? Did they actually bring a frustration defense?
No, they didn't. They were relying on the specific sanctions clause, but there is obviously an inherent problem with frustration that it's very difficult.
Right.
And
well, and particularly, this is sort of playing off of one thing Victor mentioned about allocation of risk of sanctions in contracts. I mean, surely if there's any mention of sanctions anywhere in the contract, a frustration argument is dead in the water, right? There's no way that you can say, as you must, that you can demonstrate that the parties didn't contemplate the risk, which is an absolute precondition to frustration. If there's a clause in the contract dealing with sanctions, right?
Precisely, and I think that's why they were trying to rely on that clause, but in this particular instance, it didn't work, unfortunately, for them. Turning to the new regulations in Russia briefly, on the 8th of June 2020, Russia's adopted its new law in relation to sanctions. It's the law amending the Arbitrage Procedure Code, and it's for the purposes of protecting private and legal persons from what they call restrictive measures, which are basically sanctions. And this has been enacted by Articles 241, 2481 and 248 number 2 of the procedure. There are two conditions which give the Russian courts exclusive jurisdiction over certain disputes. And it's just expanding on what Victor said a little bit earlier, and I think that you were questioning about, Noah. So the conditions where it can take over this exclusive jurisdiction is it's basically like an anti-suit injunction. So if the case is not pending before a foreign tribunal or court, it's possible to reach out to the Russian court in advance and see if they will accept. Or alternatively, if the dispute resolution agreement is unenforceable because one of the parties is denied access to justice because of sanctions. And I'm going to tell you what that means, because there have been two cases where this law has been tested. I'll run over, first of all, Uralvagonzavod against PESA, which is a Polish company. And in this instance, the Russian court considered the application of Articles 241, 2481 and 2482. And Uralvagonzavod, which is a producer of railway cars, tanks and other vehicles, claimed the arbitration agreement between its subsidiary and PESA was invalid and unenforceable due to restrictive measures opposed by the US government. The background is that in 2014, Uralvagonzavod was entered into the specially designated nationals and blocked persons list, and its subsidiary then entered into a contract with PESA for the supply of trams to Moscow. And this agreement contains an arbitration agreement that any disputes must be heard before the Stockholm Chamber of Commerce. In 2018, PESA initiated arbitral proceedings for 55 million euros owed due to a substantial reduction in an order of trams. In this particular case, the Russian court rejected the claimant's argument that it could not instruct legal counsel. And there were some really good reasons for this, because it was represented both in Russia and in Poland. The court also found, the Russian court, that US sanctions were not binding on the EU or Sweden, and there was absolutely no reason why Uralvagonzavod's sanction status would prevent a fair trial by the SCC. And also looking at Tsargrad very briefly, because I know that Viktor's touched on this, but in fact the opposite happened. So in this instance, in fact, they were not able to access legal representation, and they were told so by a UK law firm, which said they would need permission before they were able to represent them. And in this example, the Moscow Arbitrage Court accepted exclusive jurisdiction under Article 248.1 of the Russian Commercial Procedure Code. So that was quite a quick canter through the new UK sanctions regime, all of the different cases. I mean, to sum up, business in all sectors are obliged to comply with sanctions, and they have to have controls in place. Historically, especially in the UK, enforcement actions have been more prominent in financial services, but other sectors are really receiving significant fines now, and failure to comply or obtain the correct license can lead to significant fines, as we've seen happen to Standard Chartered. Companies need to be able to keep pace with these ever-changing sanctions landscapes, stay compliant, manage risk. And as you've seen, it's not just the UK list, it's the EU list, it's the US list. So altogether, they really need to carefully negotiate their force majeure or sanctions clauses, taking into account the decisions in the cases that we discussed earlier, especially La Mesa and San Juan, Banco San Juan, so that they don't fall foul of instruments abroad, such as the anti-sanctions law in Russia, for example, that disputes can be heard in accordance with the dispute resolution clauses agreed upon at the time of entering into the contract and not subject to other conditions.
Thanks, Ben. Let me just play on the title of your talk, which is about access to justice. And we saw at the very end of these anti-sanctions sanctions that the Russian government has implemented through the Arbitrage Procedural Code. If there really is an impediment to arbitration, and you suggest, although frankly I'm not convinced, maybe you'll tell us more, in Tsargrad, that a party cannot, because of restrictive measures, actually have a fair shake. Can't hire a lawyer, can't pay them, maybe can't be paid if it wins. Say it's the claimant and it can't be paid if it wins. Would an English court accept jurisdiction that otherwise lies? Let's assume it's about an English transaction, otherwise jurisdiction isn't a problem, right? Let's say if there were no arbitration clause, jurisdiction would lie. Let's say the respondents are in England, that's the easiest one, right? Would an English court say, we'll accept jurisdiction despite the arbitration clause, because frankly, it's not fair to do otherwise. We'd be denying justice to the Russian party unless we give them access here to the English courts?
Yeah, I mean, the very short answer, Noah, is yes. And I'm involved in cases at the moment where there are sanctioned individuals. It's in being heard by the English courts without any problem at all. They have the right to representation and to be heard in the English court, regardless of their sanctioned status.
But my question is a little bit different. Were those people subject to an arbitration clause, or they simply sued in the English courts?
Those particular people were simply sued in the English courts.
Right. So I'm asking sort of the more invasive aspect of access to justice. Will the English court ensure access to justice by disregarding an arbitration clause where it's proven that it won't be effective?
Very good question. I think it would depend on the merits of each particular case, and they would look at the arbitration clause and see if they were able to give validity or not. So I don't know if there have been any cases on that subject matter.
No, I suspect there haven't. What do you think the approach of English law would be to that? In Russia, they took the position that in the absence of new legislation, which is the one that you just covered, an arbitration clause would have to be enforced, right? There is no other exception to the enforcement of an arbitration clause pursuant to Russian law, and in particular law on arbitration. So in a sense, the legislator had to create a loophole. That may or may not be the case in other places.
Yes, well, there's no anti-sanctions law at the moment in the UK. Obviously, no need for it at present, and I think they would be heard if it was the jurisdiction was England and Wales. But obviously, it would remain to be seen how they react when those cases come through, if they do.
Mm-hmm. And what do you? I mean, to me, this anti-sanctions law in Russia, it's not the first part isn't that shocking. The part that you describe is actually, as I say, you could imagine a court in another country saying normally these parties should go to arbitration because they agreed long ago to do that. But because of supervening circumstances, that is not going to give them access to justice, and that is a fundamental public policy issue, and therefore will, in those particular circumstances, disregard the arbitration clause and hear their claims in court. But the Russians went further, right? And there's a rather draconian anti-suit aspect where the legislator has said, not only will we hear the claim, but if the foreign party persists in enforcing what it sees as its rights under the arbitration clause, we will impose a penalty equal to the amount claimed, not the amount awarded, the amount claimed, as I recall, which seems rather radical. What do you think about it? And I'd like to hear Viktor and Ays's view on that too.
Yeah, sure. The fine is obviously substantial. It's good that you picked up on that point. I think the access to justice point is very important, especially if you can't pay solicitors or get representation, but very happy to hear the other panel members' views with regard to the fine element.
Viktor?
I would say that it depends, first of all, but how we get there. If we get to the second part of the question via first part of the question, so we basically establish that there, for example, English court, and there a Russian party and I don't know, French party. And it seems that English court rejects access to justice to Russian party. And this is proven thing that it is like that, yeah? And we have facts. And then French party can do everything it wants in these proceedings. Then it might be justifiable for Russian court to somehow to get in and to say, okay, I suppose we should protect the interest of justice here. But as from my, let's say, experience with arbitration and international proceedings, it's really unlikely to happen in such a harsh way that the Russian party will be, let's say, so rejected its access to justice that it needs to be, that another party needs to pay a fine of the amount in dispute. I would say that the likely question will be still no, that is not reasonable.
I mean, and access to justice is such a loaded term as well, isn't it? Even if it's said, for example, that a Russian party, for example, can't get UK representation in an LCA arbitration seated in London, is that a denial of access to justice? You go to come to Paris, find a English qualified here in Paris, find English qualified in Switzerland outside the EU regime if it's about EU sanctions, or in Singapore, right, where there are plenty. It seems to me pretty unlikely that there's really going to be a closing of the doors unless there's something, some kind of consequence of sanctions that we really haven't seen in practice yet. Doesn't that seem right?
But if we heard this example just recently, China imposed sanctions on specific UK English chambers, yeah, and there was just right away some movements, and some partners need to move to the other chambers, as I understand. So basically, once Russian party comes to UK lawyers saying like, please represent me, and these lawyers saying like, okay, we might, but we have big practice with Americans and we have big money coming from US projects, so we rather not. And this, at some point, this becomes a question of access to
Yeah,
justice.
but okay. I mean, it's a big market. You'll always find a lawyer or a law firm who doesn't have that commercial interest.
Yeah,
There's
yeah,
a
of
big
course. Yeah.
difference between commercial interests and an absolute prohibition, which, you know, I have my doubts about that you know, exchange with the UK law firm that they had, that if they had gone down the street, they would have gotten the same answer about getting a license. I don't think everyone would have shared that view on that particular transaction. Ays, what do you think?
Well, I think that we shall apply a high threshold here. You know, I mean, for Russian courts to not to just rely on the fact that the party is a sanctioned person, and the fact that even if such party haven't tried to, as you mentioned, find the law firm which will be able to provide legal services, etc. So my hope is that Russian courts will not use such provisions in a way that the mere fact that the party is a sanctioned person will be absolutely all right for them to use the provisions, the recent amendments to the arbitrage procedural code. But what we see from practice, what Ben has covered recently, is that probably there will be a shift to this approach, but again, hopefully it will not be the case.
So we've got another question here directed at Ben, but I suppose anyone could also take a cut at it. Some counterpart, this is from Luba. I don't think you covered this one from Luba, Ben. Some counterparties try to use the force majeure clause that lists inter alia a decree or order of a state authority impeding the party from performing the contract as a force majeure event. In other words, that's part of the definition. Subject to the wording of the clause, do you think that in the absence of a sanctions clause, a party can rely on force majeure, even though normally sanctions may well be foreseeable?
Very good question. I think it's definitely going to depend on the wording of the clause, because very much interchangeable between sanctions clauses themselves and force majeure. But as you say, sanctions are very much at the forefront of everyone's minds at the moment. So how it could be unforeseeable is difficult to envisage. The wording would have to be.
Yeah, and of course, keep in mind, while you know, normally we think of force majeure as being an unforeseeable thing, an unforeseeable event, and that in many legal systems is the definition of force majeure. In English law, there is no definition of force majeure. Force majeure is what you agree is force majeure. So in a sense, the wording of the clause defines everything. If you say that force majeure includes, you know, impediment by sanctions, then it does. Even if you 100% knew that that was coming. And indeed, if you listed it in the force majeure clause, it means you probably saw it coming, at least the possibility that someday it could come. You just didn't know when, to what degree, and so on, right?
May I just ask, does it basically work like negative covenant in a way? So you just say in the force majeure clause in English law governed contract, events which suspend your obligations, and you just seem to call it force majeure because in the continental systems they call it force majeure, but the English law does not really like embrace the concept if contract does not.
Force majeure is just it's a kind of clause, right? It's not a term of art. It doesn't carry a legal meaning. So if you had a force majeure clause that actually didn't name any force majeure events or describe what they are, it would have no effect. I mean, it's not like it means something by itself. You can't just say force majeure relieves you of liability. And so everything depends not only on what you call force majeure, but what the effect, you have to describe what the effect of force majeure will be. You have to say it will suspend so long as you acted reasonably and you took mitigating steps, and right?
My point is that basically English law may omit, like parties in English law may omit requirement of foreseeability. They do not really need it. They just list of events. And
I think that's right. I think that's right. The foreseeability, you know, unless there's an interpretative question, you know what I mean? If you get into a question as to, you know, a certain event, one party argues falls within one of the described kinds of events, right? but it's not listed specifically, well, then you might get into a question as to, well, the more unforeseeable it was, the more likely the parties intended, or reasonable people in the place of the parties, which is the the way you have to approach it, would have understood this to encompass that event.
That's lots of fun, actually. Yeah.
Oh yeah, lots of fun, lots of fun. More questions. We've got 4 minutes left, and I'd love to hear have at least one more question from the floor.
Or comments, perhaps. I know that there were people from ICC Arbitration Court and from Hong Kong International Arbitration Center who registered. If they have any views on that, that will be also interesting to hear.
I'm going to gift you the 3 minutes then. I want to thank our panelists. It's been a really exciting discussion. Thank you for letting us know about the very latest in this ever-changing field. And in particular, Ben, I didn't know about those 2 cases. I had in my mind, having read many times the amendments to the Arbitrage Procedural Code, I was wondering when the first cases would come down. And I'm gratified to see they go both ways. That's in a sense, it's a good sign. Whenever something is new, the courts try to, understand how best to apply it, and too much consistency could be troubling, if you see what I mean. But thank you very much. Thanks to the organizers for setting this up for us, and to all of you for attending today. Thank you, and I'll hand the floor back to Jarek.
Thank you, Noah, as well, for very skillfully managing this panel and for your proactive approach to presentations. And I think the topic of sanctions will keep us busy, unfortunately, for quite a while. I suspect there will be more sanctions against Belarus, for example, very soon, and more things to discuss for us lawyers. With that, I would like to invite Dmitry to make a few remarks, and then I will make my concluding remarks to finish this event. If anyone else wants to speak or ask questions to anyone present in our virtual room now, please feel free so. But Dmitry, over to you.
Okay, if no further comments are present, then I would like to summarize that today it seems that there is an ever-increasing variety of issues which relate to international dispute resolution and even are crucial for it, especially for those the dispute resolution involving parties from the CIS region of former Soviet Union region. International business has now to take into account really numerous factors of different nature, which include, for example, anti-suit injunctions, various sanctions and counter-sanctions, different and often self-contradicting approaches of national courts to enforcement of foreign judgments and to arbitral awards, various interpretations of public policy by national courts, and various approaches to granting security measures for foreign proceedings. States are improving their toolkit to defend themselves from loss of significant assets. At the same time, protection of foreign investors, of course, remains on the agenda, and therefore states have concern how to reconcile these contradicting interests. Due to current economic crisis caused in particular by the pandemic, it has become important for parties to international disputes to maintain and to implement strict budgetary limits, and also to look for additional tools for financing judicial and arbitral proceedings. Such tools, of course, include third-party funding, and meanwhile, legal regulation and case law on third-party funding is yet developing in many countries. Well, these 2 days we have shared our knowledge and opinions on many important issues relating to international commerce and its smooth operation. As can be seen, political and other external factors strongly influence everyday life of companies involved in cross-border business. Really, work of international lawyers has become even more challenging today, and tasks have become more complex than ever. International lawyers now have become true pilots for businesses, leading the companies between numerous prohibitions, penalties, barriers of all nature. And I think that events like today do help lawyers to keep abreast with rapidly changing landscape of legal regulations, judgments, and practices. We thank all those involved in discussions yesterday and today, and we hope to see all of you on our future events.
Thank you very much, Dmitry. And a few words from me to conclude. We had over 70 people who registered for this event, and at different points in time, they joined us either to speak or to listen or to give comments. And we discussed a range of issues, starting from updates from various jurisdictions. Then we also discussed treaty law issues, public international law problems related to old treaties, to new treaties, to treaties which are not usually discussed, at least in the West, for example, intra-CIS treaties. And then we concluded with discussing enforcement with a great presentation from a representative of the Russian Ministry of Justice. And then we ended with sanctions and ever-changing landscape related to sanctions. And I think it was a very appropriate way to celebrate the 10th anniversary of CIS Arbitration Forum. That was the original idea, actually, to celebrate the 10th anniversary of the forum. And we would welcome your articles, your ideas about what we should do in the future. I would like to thank our sponsor again, Carrie Olsen, for their support of this event. We will send you a follow-up email with all presentations available, and we will be thinking how to best upload the videos. And please stay in touch, and we hope to see you at other virtual and offline events in the future, be they in London, in Moscow, Almaty, Paris, Yerevan, in all other places from where our speakers came. Thank you very much. And on this, we conclude this event, but we will not end this meeting. So if you want to chat or speak to anyone else, then please feel free to do so. Thank you, and enjoy the rest of the day.